They're all going through an emotional event. Whether it's emotionally traumatic is unique, and it depends on the person.
You'd have to prove that you were a victim of domestic violence to get that.
I would hope that anybody is now starting to be aware of signs of depression, and that people are really desperate and lonely at times.
So if someone brings proceedings against you without any evidence, you're going to have to defend it at your own cost.
Yes. General awareness of each other, that one of the things that causes emotional trauma is relationship breakdown.
Legal aid is something that the government provides. It's funding for clients that are eligible to cover their legal costs for advice or representation in court.
Thinking about wasted years, regret, trying to find your identity again after being a couple for so long. It's really hard.
If you have chosen to separate, I would assume you would not want that person to benefit in the event of your death.
Humans aren't designed to be islands. We need connection.
So we find when we have new instructions that we always advise them to get a will straight away on separation. And some of the time they're wondering why, and if they change their will now, will they need a new one after divorce?
Yeah, I see that. No, absolutely. I think the time between separation and divorce being concluded, so you decree absolute, I think that's absolutely vital to have a will in place. I suppose there's kind of two scenarios really there. It could be that you're entering that phase without a will, or you're entering that phase and you've got a will that's obviously going to be no longer any good to us. So the first bit, if they're entering that phase without a will, then the intestacy laws will apply. And that will still treat your ex-spouse to be as your spouse.
So if you died then before your divorce, your estate will go to your ex, which you probably don't want.
Yeah. There's some variations there depending on the size of the estate. Some may still go to children under intestacy, but your spouse will be your primary beneficiary. They will certainly take the bigger part of your estate under intestacy. With a will in place, so your husband and wife may have made a will previously benefiting each other, then you enter this period of separation. That's not going to be what you want, I assume, anymore.
No.
You probably would prefer to benefit your children. So at that point, they're in a period of time with a will that's no longer suitable. So again, for those people, it's hugely important, I think, to make a will at that point that's going to be under the terms that they would wish.
Because you can be separated for quite a while before you actually get that final order of divorce now. It could be over a year.
Could it really?
And then in that time, we've had it unfortunately where clients have become terminally ill and then subsequently died, and thankfully they've come to you and changed their will.
We've got quite a good relationship, haven't we, between departments? So I think, you do refer an awful lot of clients to us, and we will always try and get those wills prepared and finished quickly so that there is that peace of mind, really. It's one thing that they don't need to worry about.
But does it matter if they have a mirror will? Because I know if they have a mirror will, both of them are giving the estate to the other, aren't they? To put it simply. So can one person change it and say, I'm separating, I want it different now?
So there's a mirror will and a mutual will. A mutual will is when you're tied in. A mirror will is just the matter of husband and wife, or partner and partner, looks very similar. So they might leave to each other on the first death, and then they might leave to children on the second death. So absolutely, that does not matter. Your new client, let's say, who is in this position, they can make their own new will at that time.
Are there any disadvantages to changing the will?
I don't think so. I think there might be some risks, which maybe I'll just touch on, but I don't think there's a disadvantage. I think if you have chosen to separate, then I would assume you would not want that person to benefit in the event of your death. So I think immediately you put a will in place, naming the beneficiaries that you want to inherit, then, I don't see any disadvantage there at all. The risk is that actually with any will that we make, there is a risk of it being challenged. We're in a world where that does happen. So from this perspective, the will could be challenged by spouse, ex-spouse, whatever we want to call them, because they are still legally married or legally the civil partners. So they will still have the right to challenge.
Right.
They could say, I've not been provided for, therefore this is why I want to challenge the will. On that basis, if the divorce is underway There's been disclosures. Could there be sort of a partial agreement at times?
Will it be quite clear in correspondence that they're separating?
Yeah.
Would that be enough?
Yeah, there's evidence, let's say,
Yes.
then, isn't there?
Yeah.
So at that point, the court would take that into account. They'd say, well, look, this isn't just a spouse and a spouse, where one hasn't provided for the other. This is a couple who are divorcing. They are in that process. So they would take into account facts that would be disclosed, military and whatever, family arrangements.
Is there a conditional order? Conditional order and
yeah,
divorce, I suppose, will show the true intention to carry on.
Yeah, absolutely. And then at that point, they would treat the claim that's being made on the basis of, well, look, what would happen if the divorce had continued, if that had been finalised? Let's look at it on that basis rather than just it's a death that has caused this event.
Right.
They would look at what was going to be agreed under the divorce. So you're going to be in a better position. I can't guarantee you or a client that a claim wouldn't be made, because like I say, they always could be. But I think you're going to be in a better position. You've got an up-to-date record of your wishes, your views, and you've got the progress that's made so far in the divorce. Those things together, the court would consider, and you've got to hope then that the right decision would be reached as a result of any claim.
And what would a will say in it that it's being made or changed in contemplation of divorce?
Absolutely. We always refer it to the pending divorce, and we would ask in that situation, that is taken into account. I have not provided for my ex, whoever, because of this pending divorce.
And would another bit of evidence be that they've actually severed the joint tenancy as well on the family home? Because I always say they should be doing that at the same time as changing their will.
Yeah, we would always advise that. So for people that don't know about the joint tenancy, there is an automatic right of survivorship. So if you own property as joint tenants, you are almost seen as one entity. On the death of one, it passes to the other straight away. The severance is literally as it says, isn't it? It's splitting it, and you're then called tenants in common. So for a divorcing couple to do that severance, you have instantly protected your half, whether it's your half or your share.
Because that half goes then to who you've stated in your will, and not automatically to your ex.
Absolutely.
So that's vital, because you assist with that straight away.
Absolutely. Yeah, we would get that done almost instantly. The relevant signature is really, really quick to get that prepared. So yeah, I think that's a great idea.
Yeah, and if they were to do that as well at the same time as you prepare their will,
it all kind of goes hand in hand.
Yeah.
Because then obviously we're referring to where they want to leave that half of the house in their will.
Yeah. Would you be able to provide them with a package for that?
Yes, we do that as a package. Yeah, we do.
That's really good to hear from our clients.